The envelope arrived on a Tuesday morning in late November, just as the first major snowfall of the season blanketed my property in rural Montana. I was standing in my kitchen, coffee in hand, watching the flakes drift past my window when my wife Sarah handed me the mail with a concerned expression. "This one looks official," she said, tapping a cream-colored envelope with the return address of the Pine Ridge Homeowners Association. I frowned as I tore it open. My property sat on 10 acres at the end of Mountain View Lane, a private road I'd built and maintained myself for the past 8 years. I wasn't part of any HOA. I'd specifically chosen this land because it was outside any HOA jurisdiction. The letter inside made my blood run cold. "Dear Mr. Mitchell, this notice serves to inform you that you owe the Pine Ridge HOA the sum of $3,200 for snow removal services rendered on Mountain View Lane for the 2023 to 2024 winter season. Payment is due within 30 days. Failure to remit payment will result in a lien being placed on your property." I read it 3 times, my grip tightening on the paper with each pass. "This is insane," I muttered. "Mountain View Lane is my road. I own it. I built it with my own money when I developed this property." Sarah peered over my shoulder. "Can they even do this?" "No," I said firmly. "They absolutely cannot." But a knot of worry formed in my stomach. I'd heard stories about HOAs overstepping their bounds, bullying homeowners into submission through threats and legal intimidation. I wasn't about to let that happen to me. The next morning, I drove to the county recorder's office in town. The clerk, a woman named Marjorie who'd worked there for 30 years, pulled up my property records on her computer. "Yep," just as I thought, I said, leaning over the counter. "The deed clearly shows that Mountain View Lane is a private easement on my property. It's not a public road. The HOA has no jurisdiction here." Marjorie nodded slowly. "You're right, Mr. Mitchell. According to these records, that road is entirely within your property boundaries. You're responsible for its maintenance, but that also means you control it." I took copies of everything: the deed, the survey, the original development plans from when I'd built my house. Armed with this documentation, I called the number on the HOA letter. A woman answered on the third ring. "Pine Ridge HOA. This is Deborah Winters, president. How may I help you?" "Ms. Winters, this is James Mitchell. I received a bill for snow removal on Mountain View Lane, and there's been a serious mistake. That's a private road on my property. Your organization has no authority to bill me for services I never requested." There was a pause. When she spoke again, her tone had shifted from pleasant to icy. "Mr. Mitchell, Mountain View Lane provides access to 3 homes in the Pine Ridge community. We've been clearing that road all winter, and those services cost money. You benefit from our maintenance, so you owe your fair share. Those 3 homes," I said, keeping my voice level, "are accessible from Pine Ridge Drive, which is your community's road. They don't need to use my road at all. And even if they did, that doesn't give you the right to bill me." "We'll see about that," Deborah said. "Our attorney will be in touch." She hung up. Sarah looked worried when I told her about the conversation. "What if they really do put a lien on our property?" "They can try," I said, "but they're going to lose." 2 weeks later, a second letter arrived, this one from a law firm. They reiterated the demand for $3,200 and added that legal fees would be added if I didn't pay within 14 days. I noticed they conveniently glossed over the fact that Mountain View Lane was private property. I decided it was time to do some investigating. I drove into the Pine Ridge community, a development of about 50 homes with its own private roads and common areas. At the entrance, I noticed a large sign: Pine Ridge HOA, professional snow removal by Alpine Services. I took a photo of the sign, noting the company name. Over the next few days, I did my homework. I discovered that Deborah Winter's husband, Gerald, owned Alpine Services. I pulled the HOA's publicly available budget documents and found something interesting. They were paying Alpine Services $45,000 annually for snow removal, significantly higher than quotes I found from other companies for similar-sized communities. The pieces started falling into place. This wasn't just about my road. This was a scam. I called every neighbor whose property bordered the HOA community. 2 of them had received similar letters. One, an elderly man named Frank Carson, had actually paid $2,800 out of fear of losing his home. They said they'd foreclose, Frank told me, his voice shaking. I'm on a fixed income. I couldn't risk it. That made me angry, really angry. I contacted a real estate attorney named Patricia Hernandez who specialized in property rights disputes. After reviewing my documentation, she smiled. Mr. Mitchell, you have an excellent case. Not only are they billing you for services on your private property without authorization, but if the HOA president's husband is profiting from these false billings, that's fraud. I'd recommend we file a lawsuit, not just to stop them from collecting from you, but to recover the money they've already taken from others. I didn't hesitate. Let's do it. We filed suit in county court that week, naming the HOA, Deborah Winters, Gerald Winters, and Alpine Services as defendants. We sued for declaratory relief to establish that my road was private, injunctive relief to stop them from billing me, fraud and unjust enrichment. The HOA's response was predictably aggressive. Their attorney filed a motion to dismiss, arguing that the HOA had the right to maintain roads that serve their community members, regardless of ownership. The hearing was scheduled for March. In the meantime, I started talking to more people. I discovered that the HOA had been pulling this stunt for 3 years, sending bills to at least a dozen property owners whose land bordered the community. Most had paid rather than fight. The Winters family had pocketed over $50,000 in fraudulent fees. I also learned that several HOA board members had complained about Alpine Services' high prices, but Deborah had shut down any discussion of changing contractors. When I shared this information with Patricia, her eyes lit up. This shows a pattern of self-dealing, she said. It strengthens our case significantly. The day of the hearing arrived cold and clear. The courtroom was smaller than I'd expected, with wooden benches and high windows that let in streams of winter sunlight. Judge Margaret Keller, a no-nonsense woman in her 60s, presided. The HOA's attorney went first, arguing that Mountain View Lane served as a necessary access route for HOA residents and that my refusal to pay was freeloading on services that benefited me. Patricia stood and calmly dismantled every argument. Your Honor, the defendant's entire argument rests on a false premise. Mountain View Lane is a private easement on Mr. Mitchell's property. The HOA has no more right to bill him for maintaining it than they would to bill him for mowing his lawn. She held up the survey. These documents prove conclusively that the road in question is private property.